All right, the time is 7:41. I'll call this meeting of the mayor and council to order. Councilman Kraus could not be with us tonight. She is on a mission trip to Argentina. Everyone else is present. Our first matter of business is our invocation. If we could have a moment of silence, Miss Betty Yates, many of you know, that lives over in the Poplar Maple Street area, had a heart attack yesterday. So if we could keep her and her family in our thoughts and prayers. Thank you. Tonight's announcements tomorrow on October 14th, we'll have a Board of Appeals meeting. It'll start with a 7 p.m. work session and a 7:30 p.m. meeting. October 20th will be the next meeting of the Snellville Public Arts Commission. They'll meet here at City Hall at 6:30 p.m. in the conference room. October 21st will be the fourth quarter 2014 Snellville Entrepreneur Summit at 6 p.m. here at City Hall in the community room. We're having a special called meeting of the mayor and council on October 23rd at Briscoe Park to learn more about the Phase 3 improvements to Briscoe Park. We're asking for public comment, so please come in and join us at 7 o'clock p.m. in the Briscoe Park office. On October 26th, you can watch a rebroadcast of this council meeting on Comcast Channel 25 at 6:30 p.m. Our next regular scheduled council meeting will be on October 27th. We'll begin with a 6:30 p.m. work session and a 7:30 p.m. meeting here at City Hall. And on October 28th, our Planning Commission will meet. They'll have a 7 p.m. work session and a 7:30 p.m. meeting. Now, if I could have Mr. Anderson, you want to lead us in the pledge to the flag? Former council member Joe Anderson.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Under ceremonial matters, I was asked to do a proclamation for Red Ribbon Week by the Young Marines. The Marine that asked me to do this was unable to be here tonight, but I'll read the proclamation into the record. This is Proclamation 2014-13, Red Ribbon Week. Whereas alcohol and drug abuse is one of the greatest threats to the health of our community's young people. Whereas there is hope in winning the war on drugs, and the hope lies in the hard work and determination of our communities to create a drug-free environment in partnership with organizations such as the Greater Rome Young Marines of the Marine Corps League, which promotes a healthy, drug-free lifestyle. Whereas students, parents, teachers, law enforcement officials, business leaders, elected officials, and citizens each have a part to play in the war against drugs. And whereas education is our most important weapon in fighting drug abuse, and we must remind our young people that turning to illegal drugs is never the right decision. Success will not occur overnight. Our patience and continued commitment to drug education and prevention are imperative. Whereas the red ribbon was chosen as a symbol commemorating the work of Enrique Kiki Camarena, a drug enforcement administrative agent who was murdered in the line of duty and represents the belief that one person can make a difference. Whereas the Red Ribbon Campaign was established by Congress in 1988 to raise awareness of the dangers of the use and abuse of alcohol and drugs, to encourage a drug-free lifestyle, and encourage involvement in drug prevention efforts. Whereas the Red Ribbon theme for 2014 is Love Yourself, Be Drug-Free. Whereas October 23rd through 31st, 2014 has been designated as National Red Ribbon Week, and all Americans are called upon to show their support for a healthy, drug-free lifestyle by wearing a red ribbon and participating in drug-free activities during that week. Now, therefore, I, Kelly D. Couts, Mayor of the City of Snellville, Georgia, do hereby proclaim October 23rd through October 31st, 2014 as Red Ribbon Week in the City of Snellville. Encourage all citizens, businesses, public and private agencies, media, religious, and educational institutes to wear and display red ribbons and participate in drug-free activities throughout that week, joining the rest of the state and nation in promoting the Red Ribbon celebration in a drug-free America. So proclaimed this 13th day of October, 2014. Is there a motion to amend the agenda?
Yes, I'd like to amend the agenda to enter into the record as the official minutes, the ones that I have here for July 7th, both the AM and PM meetings, July 14th. These are the revised minutes that will replace the ones that were mistakenly approved last meeting.
There's a motion to add the approval of the July 7th and July 14th special called meeting minutes to the agenda. Is there a second?
Second.
The motion is made by Councilman Emanuel, seconded by Councilman Howard. All those in favor of the motion as stated signify by raising your hand. The agenda is amended. Do I have a motion then to approve those minutes?
Motion to approve the revised minutes for the July 7th and July 14th meetings.
There is a motion to approve the minutes for the special call meeting on July 7th and July 14th. That's actually two special called meetings on July 7th. Is that correct?
Yes.
Is there a second?
Second.
Second by Councilman Howard. Further discussion? I won't be supporting these minutes. They were not they were not written by our city clerk. I don't have any problem with the actual substance of the minutes as they are written, but I believe that keeping the minutes is the official duty of the city clerk. For those in favor of approval of the special call meeting minutes from July 7th and July 14th, signify by raising your right hand. That's 4 in favor. Those opposed, 1 opposed. The minutes stand approved. We have the minutes from the July 28, 2014 business and public hearing meeting. Do I have a motion to approve those minutes?
Motion to approve the minutes from the work session from July 28th and the regular business meeting for July 28th, as provided here.
And just for clarification, Councilman Emanuel, those are the minutes that you've provided during the work session, not the minutes that appeared in the agenda. Is that correct?
That is correct.
Okay. There's a motion. Is there a second?
Second.
Further discussion?
I think we just need to point out we've been trying to get the minutes reworked into action minutes format, and that's what we have here, and that's the reason for this rather lengthy delay.
Again, I won't support the approval of these minutes. They were not prepared by the city clerk. Also, for the work session agenda minutes, they only go over the items that appeared on the work session agenda. They do not go over the discussion we had about the regular agenda items prior to that. In the work session, we discussed both the regular agenda and the work session agenda items, so I don't believe those are an accurate reflection of the discussion. All those in favor of approval of the motion signify by raising your right hand. That's 4 in favor. Those opposed, 1 opposed. The minutes stand approved. Is there a motion to approve the minutes of the August 11, 2014 business and public hearing meeting?
Motion to approve the minutes as revised for the work session and the business meeting, August 11th, 2014.
There's a motion. Is there a second?
Second.
Second by Councilman Howard. Any further discussion? My comment will stand for the remainder of the minutes on the agenda. I will not support for the same reasons each agenda item, each set of minutes. All those in favor signify by raising your right hand. That's 4 in favor. All those opposed, 1 opposed. The minutes stand approved. Do I have a motion for the August 25th minutes?
No, we don't have properly revised minutes, so I have no more motions for approval.
Then I will make a motion that we postpone the remainder of the minutes listed on our agenda, which would be August 25th, 2014 business and public hearing meeting, that we postpone September 8th business and public hearing meeting, that we postpone September 10th specially called meeting, that we postpone September 22nd business and public hearing meeting, that we postpone October 1st, 2014 specially called meeting, and we postpone October 7th, 2014 specially called meeting.
There is a motion to postpone, that will be to our next council meeting on October 27th.
One can only hope. Yes, ma'am.
There is a motion to postpone till October 22nd. Is there a second?
Second.
Second by Councilman Emanuel. Motion made by Councilman Bender. All those in favor of the motion signify by raising your right hand. That's 5 in favor. All those opposed, 0 opposed. The minutes are postponed. We have no invited guests tonight. Now for our committee department reports. Mr. Williams, Chairman of the Planning Commission, is not with us tonight, but it's my understanding Ms. Graham is with us and will be giving us a Planning Commission report. Ms. Ida Graham.
I am Ida Graham, and I do hope that I don't embarrass anyone or be out of turn. I am the Vice Chairman of the Planning Commission, and I did not know that this was supposed to be read tonight, but I'll be glad to. That's nothing new because I never had copies of the report that was read by Commissioner Warner to make a motion for, and the audience heard it when I did, so I will apologize for any infractions that I make. We had our meeting. There was no discussion before the meeting in the planning session, and we met, and the old business was LUP 14-03 RZ 14-04, the consideration and recommendation on applications in the Linwood Development Group to amend the land use plan, official zoning map of the city of Snellville, and requests for certain variances from the RM district's criteria for 361 mixed residential unit development on a 45 plus or minus 0.14 acre site located near New Hampton Drive and Tree Lane, Snellville, Georgia, and tax parcels 5041, 061-071, 073-077, 080, 085, 089, 092, 105, and 5056, 002. There was community feedback, and I will respectfully ask that you consider the minutes as they have been presented to you, because I have a disagreement with them, and this is probably not the proper avenue. I did not deny, I did not abstain. That vote was placed for me, and I was told I had to vote. And I have a situation where no one tells me that I have to do something, and I apologize. I would submit the minutes, and I do think that, and I want to go on record as being the vice chairman, that this is the best city council that we've had, and I've been here 15 years. And I do not want to embarrass you or the city. And I have spoken with all of you over a period of time, and I respectfully ask that you relieve me of this.
Thank you, Ms. Graham. Does anyone have any questions for Ms. Graham?
I don't have a question, just a comment. Thank you for everything you do for the city.
We have no consent agenda. That will bring us to our old business. If I may have just a moment. All right, under our public hearing, we have first reading CUP 14-05, consideration action on application by So Group LLC for conditional use permit for various automotive service-related uses and request for variances from the zoning ordinance and buffer, landscape, and tree ordinances for the .445 plus or minus acre property zone business general located at 2326 Lenore Church Road in Snellville, Georgia. This is the old Gwinnett County Fire Station number 12. Do I have a motion to waive the first reading and place it on our October 27th agenda?
So moved.
There is a motion by Councilman Witz. Is there a second?
Second.
Second by Councilman Emmanuel. Any further discussion? Seeing none, all those in favor of the motion signify by raising your right hand. That's 5 in favor. All those opposed, 0 opposed. The motion stands approved. B, first reading LUP 14-03, RZ 14-04, consideration action on applications by Linwood Development Group to amend the land use plan and official zoning map of the city of Snellville and request for certain variances from the RM district criteria for 361 mixed residential unit development on 45.14 plus or minus acre site located at New Hampton Drive and Tree Lane Parkway. Do I have a motion to waive the first reading and place it on our October 27th regular agenda?
So moved.
There is a motion by Councilman Howard. Is there a second?
Second.
Second by Councilman Witz. Further discussion?
I just want to advise a few people in the audience that the horse is dead.
It's never stopped you before, David.
Additional discussion? For those of you in the audience that aren't familiar with the process, under our charter and ordinances, we have to have both a first reading and a second reading. A first reading, if we did not waive the first reading, all we would do would be to read the actual application into the record, the full application. So by us waiving this tonight, we're not making any decisions. We're simply placing it on our next public hearing for October 27th tonight. All those in favor of the motion signify by raising your right hand. That's 5 in favor. All those opposed, 0 opposed. The motion stands approved. That brings us to our new business, consideration and action on award of bid for construction services for Snellville Senior Center cast stone repairs and authorize the mayor to execute the contract. Do I have a motion?
I'd like to make a motion that we postpone this until our October 27th meeting. The city manager's not with us this evening. He has some information that he has that we need to get worked out before we take the final vote on it.
There is a motion to postpone by Councilman Witz. Is there a second? Second by Councilman Emmanuel. Further discussion? All those in favor of the motion signify by raising your right hand. That's 5 in favor. Those opposed, 0 opposed. The motion stands approved. B, consideration action on approval of SPLOST expenditures breakdown. Do I have a motion?
I'd like to make a motion that we postpone this until our next meeting.
There's a motion by Councilman Emmanuel to postpone. Is there a second?
Second.
Second by Councilman Witz. Any further discussion? All those in favor of postponement till October 27th signify by raising your right hand. That's 5 in favor. All those opposed, 0 opposed. The motion stands approved. C, consideration action on city attorney's report on August 27, 2014 order directing that city attorney's fees first be submitted to the city of Snellville for administrative determination. Mr. Powell.
Thank you, Mayor. I don't know that, well, I know council is very familiar with circumstances of the pending court action, all of which has been resolved by a settlement agreement, with the exception of attorney's fees. The court issued an order on August 27th, 2014. It's entitled the order directing that attorney's fees first be submitted to the city of Snellville for administrative determination. That was the title to the order. Is the reason for this presentation to you. I have sent out to council for their consideration the documents that have been provided to me in response to the order. The order was actually directing plaintiffs in the case to actually make a filing that ultimately the language is it is reasonable and prudent to require that the mayor submit her attorney's fee request to the city of Snellville, just as all the other litigants in this action have apparently done. That was it was the requirement of the mayor to submit. That was submitted. The range of legal fees is an hourly rate from between the value of $150 per hour and $450 per hour. The total request made is $241,419.31. In your consideration of those attorney's fees, I want to make you aware of the legal posture that you are in. The case is controlled by a document called a pretrial order. All of the claims of the plaintiff have to be set forth in that pretrial order, and were. The section seeking attorney's fees is paragraph 8J, and it seeks attorney's fees under two provisions, OCGA 45-921, or in the alternative, 91514. Those are the two code sections. The general law in Georgia is that that the litigants in a case generally bear their own cost and expenses of litigation, and attorney's fees will not be awarded unless supported by contract or statute. The two provisions that are sought under the pretrial order are by statute. The fee shifting is disfavored under Georgia law, and absent an agreement, recovery is limited to certain statutory provisions outlining the circumstances under which fees may be shifted. So there either has to be an agreement or a clear statutory right. Georgia attorney's fee statutes must be strictly construed. That is, they are narrowed and have strict application to their specific terms. They will not be broadly accepted in the application of those statutes. The first provision I would take up and advise you on is the 91514, and that recovery request is defective at this point. There is no basis at this point for a recovery under 91514 because no motion was filed within the 45 days from the termination of the action. Georgia law is very clear that a party has to file. A prerequisite to post-litigation recovery of attorney's fees is the filing within 45 days of the motion itself, and no motions pending. That in itself would dispose, really does dispose of that basis for paying attorney's fees. The second requirement would be that the plaintiff must prevail and succeed outright in the prosecution of the claim, and it is well settled under Georgia law that prevailing means obtaining affirmative relief from the court as to at least some of the claims presented. We had a one-day hearing on the subject matter of attorney's fees, really, I guess, arguing mostly over the subject matter of whether or not the terms of settlement was a win for one side or the other. That doesn't meet that standard and requirement under Georgia law. The specific case on that point is that Georgia law does not recognize the concept of prevailing at settlement. That's a quoted provision. You don't prevail at settlement. So that does not meet the prerequisite of 91514. Second basis was 45-921, and it simply does not apply to city officials. It's a provision for reimbursement of county officers. The case that is most on point with regard to that, there are really two. There's a Gwinnett County case that Judge Davis is very familiar with that involved a county employee and the statute applied to. There is a Ward case, which was the application for attorney's fees under 45-921 by a state court judge, which is a state official, not a county. You know, they do work at the county. They get compensated, but they are actually a state-created position. And the court ruled that in the case of it's not the Gwinnett County versus Yates, but it's Ward versus the city of Cairo, that that the state court judge was not entitled to the benefits of that county administrative provision. Outside of those provisions, those are the only statutory basis upon which the plaintiff has requested attorney's fees or would be able to recover attorney's fees. What makes the consideration that the court has placed on us with regard to the order so very difficult is that it is anticipating that city government can take up the payment of an adversarial party's attorney's fees outside of the statutory process, when you are restricted and constrained as a city by the requirements of your budgetary approval process, where you actually allocate funds, public funds for public purposes. You can't just pay something that has no basis upon which to pay it. It becomes a gratuity, and you're paying for somebody's personal expenses in that process unless it's budgeted for and approved by the governing authority. And so that becomes a concept of, we've obviously dealt with the statutory basis. There was no contract in place for the payment of those fees. The court's order indicates that, and I'll just read that section of it, as it now appears to this court that there is apparently a contract for legal representation of the city officials and a contractual fee rate for such legal representation which may now have bearing on this case, it is reasonable and prudent to require the mayor to submit her attorney's fee request to the city of Snellville. The inquiry becomes, okay, was this a city matter raised in an official capacity with the approval of the city? And there is nothing on the city's minutes or records that would indicate that there was any approval. The court goes on to direct another 3 items as far as its order is concerned. It says the court directs that the mayor's attorney's fees be subcategorized as follows: fees connected with her initial claims against other city officials, fees incurred in defending herself against the counterclaim by other city officials against her, fees incurred connected with the intervention of the entity of the city of Snellville. Now, I'm not sure why those requirements have been set. All I can report is that that has not been accomplished by the documents that were submitted to the city. There was absolutely no breakdown in the application that was made by former Judge Clark. There was a breakdown in the larger submittal by Mrs. Miller in a coded way, and you have all been given a copy of that. But in the coding of that process, she kept a score of 1, 2, or 3 based on the category that she was supposed to itemize in. And as you can see from the front page of that application, it indicated that all those had to do with the mayor's claim as being asserted. The problem becomes when you skip over to what would be page, and they're not numbered, but the first one appears on page 7, and you've got a description of those services. Communications with potential attorney for Phyllis Marlin Richardson regarding clerk position issues, received and reviewed copies of media requests, copies for client, received and reviewed order from court regarding media request copy. And you see that's been coded as a 1 and 3, meaning claim and claim by the city. That is in some ways, and you cannot. I can't, and I don't think anybody can take those codes and sort the dollars into the categories in which the court asked. I think the court anticipated that the presentation would be made in a way where those would already be broken out and itemized in the 3 classes. Now, Ms. Miller's request at least attempts to give a code as to how you would figure it out. It just doesn't do the allocations. The other 2 applications, as you know, with regard to Judge Clark's application, he gave no breakdown. He just guessed at a percentage as to how it would break out between the claims and the counterclaims. Those do not meet. The last of those applications that were submitted by Mrs. Karen Shack made no effort at all to break down those categories. The only other analysis I could give the applications that have been made have to do with whether or not there was some kind of agreement. Obviously, there's no agreement in the budget. There's no agreement in terms of action taken by the council in advance. There was, at one point, a suggestion that with regard to the disputes that were pending in what we call the to the 2013 case, that to resolve those issues quickly and efficiently, that they would be submitted to a court with the parties actually having counsel participate in that. That was never, that suggestion was never accepted and never presented in that way. The part that to me indicates clearly that there was no contractual obligation is the tactical steps that have been taken with regard to the steps in filing the cause of action. And if you look at the first page of entries with regard to the application of Mrs. Miller, you see on the day after Christmas of 2013, there is a communication with client regarding her desire to appoint a new city clerk and the process, and that is a $400 per hour charge. That is 14 days before that event actually took place. And the tactical contractual problem with that is that there was a lot of time. There was 2 weeks between the event where the issue is being raised for the first time with regard to Melissa Arnold's employment and its implementation 2 weeks later. And to my knowledge, no one on the council, Ms. Arnold, no one was told about that. And it's one thing to plan that. It's another thing to be in an office with an attorney planning that without consulting with the city. It becomes just totally adversarial to the city's interest, to Ms. Arnold. It's not contractual in nature. It's tactical in nature. The other item that is if you're looking for documentation with regard to contractual connection, it's the reference of February the 7th, I'm sorry, that is not it. It was the reference with regard to the first entry, which was a double entry, and in that double entry there was a discussion between Ms. Miller and a lawyer by the name of Doug Dahm. It appears another time on January 31st of 2014, and in that reference you see where counsel, Ms. Miller, is contacting counsel for another party. Again, it's tactically adversarial to the city. It's clearly not an issue for presentation in terms of working out issues of dispute between the parties. It's actually encouraging hiring a third-party lawyer to actually bring action, is what it appears to be the reference. Hiring an attorney, which is a local attorney, Doug Dahm, to be hired. And obviously that did not come to fruition. It didn't. They didn't intervene. There was no intervention. Again, citizens should not be paying for a tactical attempt to bring a third party into a cause of action. Secondly, when it actually turns out not to be something that was actually done, then it falls into the category, as you see, a great deal of the first 2 months of the time entries of Ms. Miller are dealing with the recusal of the city attorney's office. And if you think back to the issue of 9/15/14, you have to prevail. And clearly the court ruled in favor of the city council with regard to that issue. One of the other gaps to me in the logic of the fee application is the void of entry or explanation as to why you have 3 lawyers of a charge caliber of $400 to $450 an hour actually trying the case. I mean, it is one that, to me, case is much simpler than that. And so from a city standpoint, just the concern about why do we have so many lawyers involved in the case. There were 2 law firms involved on the part of the city council. That was created by the allegations of conflict of communications and interests by the plaintiff, where the plaintiff actually forced that to occur. And so the tactical question to me is, okay, why does that have to be recorded that way, and why does it have to be filed? So I'll be glad to answer any questions you might have. My recommendation at this point is that the application has not met the terms that the court requested, nor does it provide a basis upon which this council could award or pay any attorney's fees.
Questions for Mr. Powell?
Mr. Powell, when you say that the application has not met the standards required by the court, I guess my question to you is, what application is that? I didn't actually see an agenda item put forward that is following, in my mind, what the court was requiring, which was ask for the city to approve the attorney's fees. I don't see that. Since the initial court hearing, this is our third city council meeting, and I was surprised, frankly, that there was not anything on the agenda other than your report that you were going to provide to us. So I guess my question is, what application was actually made to us?
We provided. There was no application. There was, to me, it was a pretty specific that the mayor had to submit her attorney fee request. That did not occur. I did receive and shared with council 2 independent communications from the attorneys in the case asking for their fees to be paid. And that's what's been provided. And when I refer to it as the application, it's the letter of Mrs. Karen Shack and the email of Ms. Miller. And I give Ms. Miller, in terms of detail, she obviously gave more detail and had a code which you could at least determine she had put those 3 categories in a column, but there was no division of the entries with regard to the. So if the court were looking at it and saying, okay, well, the court will consider awarding attorney's fees with regard to the issue of the counterclaim, you couldn't. There's no way to make a determination as to what that amount would be, which is what I interpreted the court to be requesting.
I'm sorry, go ahead.
Follow up with another question. Also, as you went through a few of the entries here on Ms. Miller's bill, and to be honest, because we couldn't actually follow, this wasn't done the way the court ordered. I did not go through every entry in all of these bills. And in fact, Mr. Clark's bill, I had to go back to the one that was submitted. I had to go find it, that was given to you on the day of the hearing, that was not even presented to us again. But in Ms. Miller's bill, there's an entry on January 17th of 2014 that talks about part of the entry. Again, this is coded in 2 sections, 1 and a 2. And it says, obtained copy of answer and counterclaim from 2013 case. And the same reference is made regarding pending 2013 case, which I believe we call counts 1, the first lawsuit that was filed against the city. The first entry was a $2,300 entry. The second entry was a $1,392 entry. And it was my understanding, of course I'm not a lawyer and don't follow a lot of the things that you say, but it was my understanding that pending 2013 case was not a part of this action whatsoever, and the judge was very clear that he didn't want to include anything. So now we're left with some charges here that are clearly related to that case, or obtaining papers or whatever, reviewing that case, and now that wasn't a part of this, and we're being asked to pay for those fees. Is that?
And I think that's a mistake on the part of the billing, and it makes it impossible for the city council to actually consider the fee request, because you're exactly right. The ruling was that in order to avoid supersedious, the same counterclaim was already pending. These issues were already pending in the 2013 case. The court bifurcated the counterclaim, which is the reason why I thought the court wanted to see that portion of the expenses itemized so they could be subtracted out because it was not part of this case. I mean, that to me would be but you can't do it from this fee request. It doesn't give the detail that the court asked for. Obviously nothing in this case. That case is still to be tried. There is nothing in this case that resolved that counterclaim issue. Now, I didn't do it, but if you itemize, there are tens of thousands of dollars in research regarding open meetings in the billing, and we all know that ended in a settlement that confirmed there was no open meeting request. It's hard for me to. That's not something that the city has an interest in pursuing. It's a private claim. It was resolved by settlement. It was resolved by settlement and an admission that it didn't occur, and it's in these billing, and it's sort of carving those things out. You're being asked, or the citizens of Snellville are being asked to pay for the hearing with regard to the recusal of the city attorney's office in here. Well, the council members in the city prevailed in that action. There's not a legal basis upon which it can be paid. From the flip side of that, the city did not pay for the defense of the law firm. We unfortunately had our own attorneys who had to step in and defend those ethics issues, and did very successfully. We're very grateful for Ms. O'Neill's work, but it was not a city interest, and so those are accumulated in here and put in categories that have multiple connections on Ms. Miller's billing, but make it impossible for this council to consider any kind of relief.
When you first started, you mentioned an entry. I think maybe you said page 7. Could you give me the date on that concerning the hiring of an attorney for Ms. Richardson?
Yeah, it is. That's February 7th of 2014.
2/7 or 2/6?
Is one entry. 2/7/14.
2/7.
And that's the one I was reading from.
And then up here. And then also on 2/6,
Yeah,
Meeting
there was
with
another
attorney
one
for Ms.
earlier
Richardson.
than that. Yes.
regarding Gwinnett lawsuit.
Additional questions for Mr. Powell?
I was under the impression that what we're really looking for is an aggregate bill in each of the categories defined by the judge. We're not really looking for individual charges by each attorney. Am I correct in that? That we're just really looking at how much money was spent in total in each of the categories, the subcategories defined by the judge being 1, 2, and 3.
I think if it was submitted in the three categories broken down in 3 lawyers, it would have been fine. But two of these summaries were presented in the same form that the court had it before it issued the order. I mean, it hadn't changed it a bit. So, I mean, the court wanted something done that would itemize the billing in a more formal way. Now, 1 sheet or 3 sheets. 1 sheet, I think, would have been effective. Yes. Yep.
Okay. And is it reasonable to expect that? I noticed the majority of the charges were applied to all 3 subcategories. Is it reasonable to expect that the majority of charges were actually addressing all of the 3 subcategories? I would think it'd be more broken down, that you would have certain work that was done strictly for initial claims, certain work that would have been done for incurs in defending against counterclaims, and then certain work that was incurred relative to the intervention of the city. And it would seem that there would be some overlap, but not the majorities. Am I correct in assuming that?
Not just this court's order, but any court awarding attorney's fees, you have to meet the statutory requirement, and then you have to prove the amount. So it can't be foggy. It's got to be precise, and that's with regard to whether you have this specific order that Judge Davis has issued, or if you're just applying under 915.14 for attorney's fees. You've got to be able to break out the part that you prevailed on versus the part that you didn't prevail on. and show which fees. And that's sort of what the court was asking to occur. It did not occur in this case. The fog is there on all of those entries.
Additional questions for Mr. Powell? I have a few comments. First, Mr. Powell, I would go back and rethink your tactics argument. 2 days after Christmas, I was having heart surgery at St. Joseph's. I wasn't planning tactics of a city clerk, so you may want to go back and look at that. For those of you that are unfamiliar, what we're discussing tonight is the payment of attorney fees for myself in my official capacity as mayor of the city of Snellville when I was forced to file a lawsuit not against the city of Snellville but against individual members of council after they failed to recognize the appointment of Phyllis Moreland Richardson as city clerk, and after other actions occurred such as my having restricted access to the second floor of City Hall. We settled this lawsuit in June of 2014. One of the reasons I agreed to settle was because at the time I had found out I was pregnant. I'm now 7 months pregnant. I'm not going to get stressed out about this today because it's not worth the health consequences. But as he's done in the past, Mr. Powell has stood before you tonight and made a presentation of the members of council's side of the case. I fully intend that on October 24th, both sides will be determined. In the settlement agreement, the issue of the mayor's attorney's fees was left open, and that it would be determined by the judge, and that's what I fully intend will happen on October 24th. What Mr. Powell hasn't told you tonight is that the members of council use not just the services of Mr. Powell, but also of Kevin Talent. In their individual official capacities, there was no signed contract that came in front of the mayor and council to retain Mr. Talent. But the members of council have approved $115,000 for their individual attorney's fees for payment of this lawsuit. That was something that was not budgeted, and that's something that there was not a signed contract approved by the mayor and council officially for. The fee amounts, I agree, the fee amounts that have been read by Mr. Powell tonight, $450 an hour, is an extremely high amount, especially for government work. But what he has also failed to mention is that the attorneys in the initial hearing said that they agreed to the $150 rate that Mr. Powell and other government attorneys charge. The government rate, the total amount Mr. Powell's provided tonight is based on the higher hourly rate. The government rate would bring it down. I haven't done the math. I'm not sure what it would be. What the attorneys have asked for is that the council consider the fees in general. If there's any amount they're willing to pay, then to let them know that, so that we don't have to go to court on this issue and continue to incur legal fees on both sides. This was an unfortunate situation. We settled it, I believe, all of us, so that we could stop spending the taxpayer money fighting over this, and so we wouldn't have appeals costs to pay. But these attorneys did their job, and it'll be a court to decide, I guess, who prevailed and who didn't prevail. That's something that, even though we agreed in the settlement this was a compromise and we're going to move forward, unfortunately that hasn't happened, and there's continued to be bickering over what the settlement actually meant. But I will leave this to the judge's decision on October 24th, and we'll all have to just live with whatever he decides. So.
Mayor, the only thing, and I didn't want to mischaracterize the entry on the day after Christmas, but it says communication with client regarding her desire to appoint a new city clerk. And
perhaps Ms. Miller made a typo or got her dates wrong.
You're saying that didn't occur.
I'm not saying the meeting didn't occur, but I don't believe that date is accurate.
Okay.
Mr. Powell, did the attorneys submit the bill for $240,000, or did they submit a bill with reduced fees down to the government rate?
I have never, I'll be honest, I've never heard that before.
What did they present to you?
I had the impression from the court that the court was saying, you know, he wouldn't consider anything other than the government rate. But I've never heard a concession from the plaintiff side that there was any offer to be paid $150 an hour.
And what you received to bring forward to this council is $450 an hour, correct?
It is.
Thank you.
It is. And let me say this: there is inside that the email from Ms. Miller, and I didn't bring it with me, but it was a suggestion of negotiation. It was one. This is what we're asking for. but we're flexible to negotiate. And that's not a quote, but that's just the impression I had.
Mr. Powell, the itemized bill from Mrs. Miller totals $166,576.28. Wouldn't it be reasonable that if they were charging $150 an hour and were fully willing to negotiate to that point, that they would have based their billing that we received on that rate rather than billing it at $400 an hour?
And this goes back to it's the judges, what the judge sort of was, and that's not something any of us can rely on. It was conversation in the courtroom about what's reasonable under these circumstances, and government lawyers make less than $400 an hour.
Ms. Karnashak actually submitted her bill at $150 an hour.
She did. And but from the order itself, it's implying that that's what they were supposed. I mean, if I'd been on the other side, that's probably what I would have read that and said, don't submit something that's $450. You're not going to get that. That's the way I would read it now. It doesn't say that, but it just infers that. So. But we didn't get any of that.
That brings us to item D. Melissa.
Excuse me, Madam Mayor. If there's no objections, I would like to hear public comment on this issue.
It is not on an agenda for public comment. We don't take public comment on our new business items. So I'm moving on to item D.
I'd like to ask our parliamentarian. I believe this is the lesson you gave us tonight.
Well, as a matter of fact, if you ask for unanimous consent, if you object to what was just provided, then a vote would ensue, and then the majority would make the decision on the request.
On allowing public comment, what authority allows public comment on a new business item?
If I understand the city code properly, there is permission for public comment if the city council decides on any given issue that they would allow for public comment.
I would ask the city attorney then what code section that is.
I've got that right here.
Okay. So apparently you were prepared for this, Ms. Bender.
Well, I was.
Thank you for mentioning it during the work session.
You might not want. I didn't realize there would be objection, but I was prepared in case there was.
Thank you for letting me know in the work session you wanted to take public comment. I appreciate that.
Oh, I can do that in the future. Thank you, Mayor. So do I need to make a motion to do the vote?
Can you tell me what the code section is you were about to say?
It's section 2-53, public participation.
Yeah, ease for just stand at ease for just.
That's fine.
right, I'll call this meeting back to order. We will take public comment. If anyone would like to speak for or against this agenda item, please come forward. State your name and address for the record, please.